I'll try to give you a very plain and simple overview on our data protection regulation legislation in Brazil. Remember that we in Brazil was one of the last countries in at least from the major economies in Latin America. We are one of the last countries to adopt the data protection legislation a bit late. What happened in Brazil for the whole time? We dealt with the current regulation. We had very strong pressure, first because of Edward Snowden revelation, which were huge regarding Brazil because there was a president involved. The Cambridge Analytica scandal played also a big role, but there's a particular situation that not many people know, that is that several major enterprises in Brazil began pressing for a general data protection law, and they began pressing for an independent DPA also, because they are used to have data protection laws in almost every other country they work with. They know also that in Brazil, we are a federation. We have a question of concurring competence among states. So it's what began to happen in the last 2 years in Brazil is that the data protection began to be felt by the general public, by general citizens, as a substantive issue. So cities, municipalities, states began to legislate on the matter. And some laws began to arise in several cities. Now we have, 2 weeks ago, the state of Rio de Janeiro, one of the most important in the federation, approved, the Congress of Rio de Janeiro approved a state data protection law, which is not yet enacted, but it can be enacted at any time. And they differ substantially for the general data protection regulations. So enterprises mainly began to feel the urge to concentrate, to unify data protection at federal level and with an independent authority. So they felt they would not be tied to decisions of state and municipal level consumer offices, which was one, they are very strong in Brazil. They act directly with the population, but they can have different opinions on data protection in different states. It would create a crazy madness of different interpretations of data protection legislation in the more than 900 consumer offices in Brazil. There's a very bad potential for enterprise. From the point of view of the state, I couldn't say that Brazilian public sector is so eager to adopt data protection legislation. In fact, they are less inclined to accept data protection as an issue because, of course, they will lose power. Most of the public bodies can potentially lose power because they will have a DPA which can, in theory, control. And as we don't have the experience on data protection, public bodies are afraid of being controlled by that. But what happened also is that the pressures regarding European Union adequacy, and in the case of Brazil, also because of the bid of the federal government to join OECD, which is being seriously considered. OECD has demands from the countries that try to see that they have a data protection legal framework, and specifically that they have an independent DPA. And there's also the Mercosur deal, just came to speak, the other mention, and Bruno Giancarelli mentioned this morning, which will be very important, even if it's not written literally in the treaty. We don't know the treaty because the wordings are not public as of yet, but if several sectors have to join forces, work together, of course, there will be a strong demand to adapt all the tangential legislation, including data protection, to abide by the terms of the one of the parties. So some issues of data protection which are not yet present in our law, specifically the independent DPA, will be most probably changed because of Mercosur legislation. We'll have to wait to see because the treaty was approved, but the Congress have to ratify it. The National Congress have yet to ratify it, and some things may happen. Let's see. Well, I was talking about the law itself. So if you take a look, this is a very plain resume of the main points of the Brazilian data protection law, it's very similar to an European style legislation. It is very similar because it was first inspired by Convention 108, also by Directive 1995 directive. And Brazil has a very strong European continental law tradition, so it could easily follow some traditional European steps. But of course, it was discussed by more than 8 years, and it has approved, it has also absorbed several points of traditional Brazilian law, like some provisions regarding consumer protection, civil action, the idea of the vulnerability of data subjects, and several others are very present and very strong in the details of the law. The grounds and fundamentals of the law are very generalistic, and they include, since the right to privacy and intimacy, as well as the German information self-determination principles, the freedom of expression, but also the free initiative and competition and consumer protection. We can't say that the Brazilian law is a traditional strict privacy law, because it takes note of the importance of data protection right now as an economic and commercial strong issue, as well as a general human rights perspective is important.